Good afternoon, everyone. This is an oral argument on the cross petitions of Respondents Harding Advisory, LLC, and Mr. Wing F. Chow, and the Division of Enforcement for review of the initial decision of an administrative law judge. A total of 40 minutes has been allowed for the argument, with 20 minutes allocated to each side. Respondents will argue first, and then each side may reserve time for rebuttal, which I understand both sides have. Respondents wish to reserve 5 minutes for rebuttal, and the division wishes to reserve 3 minutes for rebuttal. Mr. Lippman, you may proceed on behalf of the respondents.
Thank you. Good afternoon, Chair White, Commissioner Stein, Commissioner Piobar. My name is Alex Lippman. I represent the respondents. And at the council table, I apologize. Turn it on. I'm not sure. It's on now? I apologize. Okay. At council table is my partner, Ashley Bainham, also. What I'd like to do is, first, thank you for an opportunity to address you. We've waited this for a long time. But second, what I'd like to do is just tell you where I'm going to go, and if you have different ideas, then please tell me, and I'm happy to go wherever you want. So what I'd like to do is I'd like to first address the allegations relating to the Norma purchases, because I think that the errors there are a little bit more difficult to deal with. And I think that if I have time, I'll get back to Octans. But if not, they're cross-petitioning on it, so I think we'll be able to get to it on rebuttal. So turning to the Norma purchases. I think the most important thing to start with is what is and is not alleged in the OIP. The OIP does not allege a fraud against investors in the CDOs into which the Norma bonds were placed. The OIP alleges that the respondents violated their duties to these two CDOs that bought the bonds, because when they advised them about the purchase of the bonds, they didn't tell them that they were operating under a conflict of interest, because they were trying to accommodate Merrill and Magnetar, who were trying to sell the bonds. So the fundamental problem with that assertion is that Merrill is the bank on all three deals, and the same three individuals who were the directors of the two CDOs into which the bonds were placed are the same three individuals who were the directors of the CDO that was selling the bonds. So if anybody is being accommodated, it's the same people. And if anybody wants to know what it is what these bonds are, well, they know they're selling the bonds. They know that they're having issues selling them. They know what's in them. How they could be, and of course, the respondents understand that these are the facts. So how the respondents could be defrauding anybody by what is it that they should have said? Okay, these are the bonds that you're selling. We're going to place them into these CDOs that you're buying, and your fiduciary, Merrill Lynch, knows all about the bonds. I struggle to understand how that is a fraud. But there are two other pieces to this, and the reason that I think the ALJ came out where he came out. The first piece is that the division invited a factual error. That is, the ALJ thought, when he wrote his initial decision, that the bonds were impaired when they were bought. I mean, let me just say why that's absurd. There were BBB investment-grade bonds. So how they got into this is they said, look, here's a document, an internal Harding document. It's hearsay. Its author is not testifying, by the way. But on the document, there's a number. It says percent write-down. It says 10.17. The credit buffer, if you would, below the BBB bonds is 6.9%. So This is 10.17, this is 6.9. Clearly, it's a degraded bond. Now, in fairness, they got it out of our client, out of Mr. Chow in their case. And frankly, when he said that, I almost fell out of my chair. It's the truth. But I think, as he explained when in our case, he was stressed. He gave him the wrong answer, but he corrected it in our case and explained it. And the explanation is that that number actually relates to something else. It relates to the deterioration in the underlying pools of loans. Big difference, right? Because even though it's 10 whatever percent, there are all these credit enhancements, right? And everybody understands that this is going to happen. And now, how did Mr. Chow, so 3 things. Number one, if that hearsay document meant what the division says it meant, it was false on its face. It was not something, it doesn't make sense. The reason it doesn't make sense is that everybody does the same mathematical analysis. Everybody looks at a formula. They're looking at all of the same information, right? It's information that's available, publicly available. It's in in-text. It has loan level data. It has peculiarities of each deal. And all of that it's a mathematical analysis. Our client hired PhDs, math and physics PhDs, to do the analysis, right? But it's mathematical. So if a credit rating agency says this is an investment grade bond, you know that it's not 10.5% or 10 point whatever percent impaired. No. The second reason that you know it, and he knew it, is because they do not dispute. This is a fact. Prior to closing of the deal, they did an analysis, and they had to certify that they did analysis and that all the everything that went into the deal meets the criteria, the deal criteria that are listed in the offering documents, right? They say, oh, whatever. It's just a mechanical analysis. Yeah, it is. It's a mechanical, mathematical analysis based on information about the deals. Yes, they run a formula mechanically, but what it tells them is that the deal meets the eligibility criteria and other qualifications that it's supposed to meet, right? There's no dispute. Nobody's claiming that certification is bad. But one of the things that certification showed is that none of these securities were credit default securities. It's among the eligibility criteria. They weren't credit default. They weren't defaulted. They weren't credit risk securities. So they knew at the time that they closed it, even if whatever else happened, they knew at the time of the closing of the deal that these were not defaulted securities or credit risk securities, okay? So now, because the ALJ thought that these were impaired securities at the time that they were bought, of course, he looked at the bunch of hearsay that they introduced and read it in the worst possible way, right? Makes sense? Now, what are these hearsay? These are emails. By the way, no one other than Mr. Chow testified about these emails. None of the authors, the internal emails at Merrill Lynch between 2 Merrill Lynch bankers, neither one of them testifies at the hearing. And yet, one two-line email on which a finding of fraud and a bar, a bar is predicated. Now, if you look at the emails are, a bunch of them are just normal emails where people push and pull, people negotiating. If we can't change the turbo, one of the things was he was complaining about the turbo in these BBB bonds. So if we can't change the turbo, what's your level? And he responds, so let me sharpen the pencil. And the other guy follows up and says, well, have you sharpened your pencil? That's not evidence of collusion. That's evidence of bargaining. So then there's an email that says something along the lines of, this is an internal email that Mr. Chow is not on, that says, that I told Chow we would try and sell him down to 15 million if we could. He wants to talk about the spread, but he will be in. And the idea is that he agreed to buy 20, and they were going to give him 15 as a repayment for his accommodation. Here's the problem with that. They have now admitted. They should have given this to us as Brady. After the trial, after the post-trial briefing, after everything, they say now, hey, wait. This argument, we argued that Merrill is on both sides. This argument doesn't take into account the fact that Merrill did not know it was being accommodated. What? Really? Merrill did not know it was being accommodated. Let's look at this email. Why would Merrill cut them down from 20 to 15 if they didn't know they were being accommodated? What would be the reason for them to pay back Mr. Chow for buying 20 with giving him 15 if they didn't know he were being accommodated? He's going to stand up, Mr. Fisher is going to stand up, he's going to say, that's not what we said. What we said is that they didn't know, Merrill did not know, that Harding did not do the analysis. Let's set aside whether they did, because I think they did, okay? But let's set that aside, okay? What's the difference? If Merrill does not know that they don't like the bond, or they don't know that they didn't review the bond, well, as far as they're concerned, he says, I want 20, right? Why would they give him 15? So, looking at this email, when Mr. Chow was subjected to the craziness, frankly, of having to explain this email, this is between two people, he's not on the email, two internal people at Merrill. He says, I think they're threatening me. They say, that's just not possible. It's not possible? How about this? Look at the order. He wants to talk about the spread. I told Chow we would try and sell him down to 15 if we could. He wants to talk about the spread, but he will be in. This is how that works. They get on the phone. By the way, I do not know that this happened, right? Nobody remembers. But we're interpreting something, 2 lines from 10 years ago, among people who are not testifying. So this is how this can be interpreted, fairly. Okay, they're on the phone. I want you to buy 20. I know you need 20. Remember, these are the same. Merrill is on both sides. They know what he needs. I know you need 20. I'm not going to give you 20 if you don't stop bargaining. Okay? And so, he wants, I told Chow we would try and sell him down to 15 if we could. He wants to talk about the spread, but he will be in. Completely consistent with a perfectly innocent explanation. Completely. So,
Mr. Lippman, may I interrupt you just for a couple of questions?
Yes.
One set is sort of legal and the other factual, although I think you haven't quite finished your factual argument, but I think I understand what that is. I mean, I take it, but correct me if I'm wrong, you're not disputing that Harding owed a fiduciary duty to the Harding advised funds, right, CDOs?
we are.
You're disputing that there's no duty.
We are. And
There's no duty, as opposed to there's no violation of the duty. Which are you arguing, or both?
Both. Okay. There's no violation, but there's also no duty. And the reason for that is that in the collateral management agreement, it specifically says that this agreement does not create fiduciary. It specifically says you're not a fiduciary under this agreement. And we had counsel, Harding counsel, who did the agreement, testify that that's his understanding too. Which, even if, as a technical matter, that turned out not to be correct, which I actually think it is, because I think it would be very difficult for someone to be a collateral manager and owe duties to any specific class of investors or the CDO itself. I think that they have different interests, and so that's why this provision exists. But setting that aside, even if that were to be turned out to be wrong, Mr. Chow had no reason to think that it was wrong. His lawyer told him this. Right? In writing. So You had a factual question, I'm sorry.
No, go ahead. My factual question I think you've mostly addressed, which is, isn't there evidence in the record that Mr. Chow was uncomfortable making these purchases?
So the evidence...
And reluctant, and some evidence in the record suggesting pressure to do so, whether internal, external, or both, yeah.
So here are the two pieces of evidence on that, okay? Number one, an email in which Mr. Chow, when he's informed that he's cut from 20 to 15, says, that's what I'm talking about, the love is in the air. Is there an email that is more unclear than that? That's what I'm talking about. The love is in the air. I don't know what that means. I'm glad they do. I don't know. The other piece is, so there is a follow, later, remember, the market went off the cliff, right? And as it was going off the cliff, at some point, Mr. Chow tries to sell 2 bonds, or at least he's offering them, you know, for whatever reason. I actually don't know, okay? I think he testified that he was doing price discovery. Whatever, it doesn't matter. There are 2 bonds. One of them is the Norma bond. And so whoever responds to it writes a ditty about Norma. Because Norma Jean, there's an Elton John song. He doesn't write about the second, there are 2 bonds for sale. He's not writing about the second one, because the second one, you can't rhyme it with any popular song that I can think of.
Thank you. Your time's expired, unless you have a thought you want to finish up?
I'm sorry?
Unless you have a thought you want to finish up.
I just wanted to sum up and say these are the reasons. It fails as a matter of law. It fails as a matter of, as a matter of logic, and it fails because the evidence they presented is not competent evidence for concluding that a fraud had occurred.
Thank you very much, Mr. Lipton.
Thank you.
Mr. Fisher?
Thank you very much, members of the Commission. Howard Fisher for the Division of Enforcement. This is a case about Harding's defective asset selection process for numerous CDOs that it managed and was the fiduciary for. More than that, it's a case about lies and breaches of those fiduciary duties. Harding lied to its investors. It promised them in various offering materials and in the offering circular that when it selected assets for the CDOs it managed, it would employ certain specified analytical and methodological guidelines to ensure, quote, the suitability of each potential transaction in the context of the CDO. Harding also lied to the issuers that were its advisory clients. Harding told issuers in the collateral management agreement that it would discharge its duties as manager, quote, with reasonable care and in a manner consistent with the customary standards, policies, and procedures followed by institutional managers of national standing. But Harding broke its promises. It broke its promises to investors. It broke its promises to the issuers by failing to exercise the appropriate due diligence that it promised and represented it would follow. First, it did so in connection with several CDOs it managed when it bought Norma bonds for those CDOs, Norma bonds which were being heavily promoted by Merrill Lynch and Magnetar, who were responsible for the bulk of Harding's business. Not only did they purchase some bonds, the single-A bonds, without doing any of the analysis they promised, they then, after that analysis was done and was harshly negative about those bonds, purchased additional lower-rated bonds. Secondly, in connection with the Octans 1 transaction, Harding broke its promise of selecting assets for that CDO, even though Harding's own internal analysis and review did not support those purchases. This dereliction of duty goes to the heart of what an investment advisor, a fiduciary, and a collateral manager should do. Now,
Mr. Fisher, if I may just ask the question and really responding to Mr. Lippman's argument, really, I would call it the contractual point of, was there a fiduciary duty here to the CDO?
our point, and the point is made strongly in our briefs, I believe, and in the ALJ's decision, is that of course Harding is a fiduciary. You cannot, an investment advisor cannot attempt to disclaim its fiduciary duty. And in fact, if we look at the actual representations that were made, notwithstanding Mr. Lippman's attempt to characterize the job as merely a ministerial, where they're just checking off a couple of boxes, doing a couple of equations, they represented in both the offering circular and in the pitch books that they sent out to potential and actual clients that they would exercise discretion, they would exercise judgment, they'd perform thorough bottom-up credit analysis, in-depth credit reviews, stress case runs. They were going to exercise the obligations of a fiduciary and investment advisor. Now, to address some of the issues that were raised by the respondents on in their...
I'd like to ask a question about the industry standard of care that you're mentioning. What in the Harding materials were allegedly misleading in its representation of adherence to an industry standard of care?
There was extensive testimony by the expert, Mr. Wagner, about this, and several things violated the duty of care and the industry standard. Let me focus first on the NORMA ones. First, with NORMA, as Harding's own principal testified, they looked at three things: the structure of the assets, the structure of the deal, and the reputation of the collateral manager in charge of that deal. They violated their standards for doing that. Not only that, but they didn't actually run any analysis. A collateral manager, as the experts testified, is supposed to run some kind of analysis to determine whether or not the purchases of assets are suitable for the vehicle that they are managing. They didn't do that when they bought the single A notes for NORMA. They did it before they bought the single B notes. That review, which was a business record of Harding, produced in the ordinary course of its business, sent to everyone in Harding, showed that those assets were significantly impaired, were managed by a collateral manager that they did not like and did not respect, had an improper and bad structure, and they purchased them anyway. For the Ogden's deal, the breach is somewhat different. In the Ogden's deal, remember, this was not a deal, the purchase of the ABX constituents, which Harding itself came up with. This was a deal that was proposed by Magnetar. It then had to be explained several times by Magnetar because, as it was not Harding's deal and not Harding's idea, they didn't know how to do it. And secondly, as the respondents concede, the execution of this deal was managed by Magnetar. When looking at these assets, Harding had several analysts doing that. One of the analysts found that the assets were favored, or some of them were. Another analyst found that they were improper for inclusion. No one made any effort to determine what one hand was doing and what the other hand was doing. There was no effort made to reconcile these inconsistent analyses, and as a result, assets that Harding's own people disfavored were put in the Octens 1 transaction. That was a violation of their duty, a misrepresentation to investors, and a violation of the national standards that they represented and promised that they would follow in the collateral management agreement.
I guess just as a follow-up, this was still a relatively small industry, one might say, and it's not clear from the record that there was an industry standard of care. What should the standard of care be if there is not as yet a clearly agreed upon industry standard of care? And I'm thinking about new products or transaction structures that might not have an industry standard. Should investors at least be assured that they can rely on the, well, I'll say fiduciary self-articulated standard of care? Does that make sense? So if there's not an industry standard of care, because it's a relatively new product line, new type of structured transaction, what should the issuers be able, the investors be able to rely on as the standard of care?
Well, two responses to that, Commissioner. The first response is that with respect to the standard of care that Harding was supposed to follow, that was a representation made in large part to the issuer. There were other additional representations made to the investors which Harding violated. But what an investor should expect and is supposed to be able to receive is that when they invest in a vehicle, no matter how new, old, seasoned, or unusual it is, they have an investment manager who is actually doing the job that they represent. If they're saying that they're going to perform certain methodological and analytical reviews of collateral, they should exercise that collateral. If they are actually doing transactions because other parties to the deal, parties that are not disclosed and whose rights are not disclosed in the offering materials and in the deal documents, if they're doing deals because those parties are presenting it to them, investors should know that. Investors should also know and expect to know, no matter how new the deal is, that whether or not a collateral manager is buying assets because they think it's a good thing or because someone who they owe a lot of their business to is proposing it. And let me just point to three recent cases on this in which the percentage of assets was far smaller than the assets at issue here, the SEC v. DeBella case that the Second Circuit decided, and then the Kingsley Jennison, as well as the Michael Pelosi case decided by the Commission, all held that violations which involve far smaller percentages of assets are still violative of a investment advisor's fiduciary duty. And let's just focus
Mr. Fisher, could I just ask you, did you finish with your, under any circumstances, could the ABX purchase have been made? The ABX purchase. In other words, if it hadn't been recommended by Magnetar, for example, the index purchase.
Oh, for the Octans 1 transaction.
Yeah, for the Octans. Yeah, for the
Yes.
Octans, sorry. I mean, what precisely was improper about that purchase?
A couple of things were improper about that. What was improper, and in turning to Octans about that, was the fact that Harding had different analysts looking at these transactions, at these assets. They were looking in the context of this deal, looking in the context of OWICs and BWICs that were sent out, and one analyst, Lou, had different opinions about some of the same assets than another manager, Moy, did, and there was no effort to reconcile
But is that a difference of opinion on the constituent bonds in the index or the index itself?
Well, a couple of responses to that. The way the case was laid out, the breach relates to picking the constituents of the index itself. There's another aspect of the case which involves the aspect of using the ABX transaction as a mechanism to ramp the CDO, and what we've argued in that connection is that that was a breach because Harding never told anybody that Magnetar was a party to the warehouse agreement. It never told people that Magnetar had significant rights, including the rights to veto the inclusion of certain assets in the deal, and they never disclosed that to people.
But wasn't it common at the time that the equity purchaser of the equity tranche had those rights?
It was equity at that time was a hard-to-sell piece of the CDO transaction. So as a result, people who were willing to provide the equity were very, very sought after, and that's one of the reasons why Magnetar had that kind of influence with Merrill that structured the deal. The problem here is not that they had the influence, but that nothing of this was disclosed to the investors. And I think there are some recent cases that the Commission decided that go directly to this issue. Give me 1 second. Here, what investors did not know was the extent to which other parties had rights, and other parties were involved, and nobody attributed or gave this information to the investors. And 1 second, trying to find where I have those cases. Yes, there are a couple of recent cases where the Commission has held that there is an absolute duty to disclose this. In the Henry J.S. Oliver Capital Management case, which was decided on June 16, 2015, the Commission held, and I quote, an advisor is under a duty to disclose any potential conflicts of interest accurately and completely. It is indisputable that potential conflicts of interest are material facts with respect to clients and the Commission. Similar language was found in the September 2015 case of Timbervest. Similar language was also found in the Commission's Maloof decision, which came out about 10 days ago. The investment advisor does not have a right to decide whether or not it's going to disclose these things. Unless there are any other questions on that issue.
Just one more on
Sure.
Octans, and that is, I think you argue about the incentives of Magnetar being inconsistent, with the debt investors, but weren't they net long, in Octans?
It's a somewhat nuanced answer to that question, Chair, so give me a moment to sort of flesh that out. The reason why Magnetar's interests were not aligned with other investors is that Magnetar had a more global strategy. That strategy included, as part of it, the Octans 1 transaction. What Magnetar wanted to do, and what the testimony showed they wanted to do, was have a bunch of CDOs in which they had equity. The interest and the income on the equity would help to support their short positions in the mezzanine and other tranches of that CDO, and ultimately, whether or not the CDO failed or succeeded, Magnetar stood to make money, and in fact, they did make a lot of money when everything failed. So even though they were, and that, by the way, is the reason why, as the evidence showed, Magnetar wanted it was so important to Magnetar to put the ABX index constituents in the Octans 1 deal, because they wanted all of the CDOs, all of the Constellation CDOs that they were investing in, to have a similar structure so that when you had a long position in one, you could cover that with a short position in another because of the similarity in the assets that those structures contained. In this case, the similarity was having the ABX positions.
I have a follow-up to that. The record suggests that market participants were generally aware of Magnetar's role and tendency to short against CDOs by the time Octanes closed. Is that correct?
With all due respect, Commissioner,
Yeah.
that is not correct.
Okay.
There was some chatter in the investment community. There was an article that came out, for example, around the time of the Octans transaction, that some Chicago bank was involved in the strategy, and there were some people who were deeply involved in the structuring community who probably had a pretty good idea because they were involved in structuring Magnetar CDOs. But the fact that Magnetar was involved and the fact of Magnetar's rights in this transaction, in the Octans transaction, was not something that everybody knew. And in fact, as Mr. Doiron, collateral manager for HIMCO, who invested in the Octans transaction, testified, he had no idea, and he wished he did have an idea because that's something that he would have wanted to know.
There was also, there was another, in the evidence, the record basically notes an inquiry possibly by Morgan Stanley at the time of the Octans closing that inquired about Harding's ability to short against collateral without triggering a test. Is there significance to this inquiry?
I'm not sure. Could you
So
repeat
Morgan
that?
Stanley's asking if Harding has the ability to short against collateral right before the closing.
Yeah, I mean, clearly that showed that there was some interest in whether one party to the transaction had the ability to short it, because that does show a conflict of interest, as the same kind of conflict that would occur if an equity participant was going to short other participants. Here, however, Harding did not have any skin in the game. It didn't, unlike a lot of CDO managers, it didn't itself invest in the deals that it managed. So it had, unlike Magnetar, which had the incentive to short the structure so that if the deal succeeded, they got interest for a while on the long position, and if the deal failed, they had a 2-to-1 position generally on the shorts, so they profited on that. Because Harding didn't have any skin in the game, it didn't have that kind of incentive. But clearly it shows that this is the kind of thing that market participants would have wanted to know, and unfortunately, it was information that they were not disclosed in this transaction. In the very very limited time I have left, I just want to add one point about one of the issues that the division cross-appealed on, and that is the penalty issue. The ALJ found that for 6 violations relating to Octans 1, a first-tier penalty was appropriate. However, he declined to impose that penalty because the Commission had only asked for a third-tier penalty. It's respectfully submitted, and we set it out in our briefs, that the law is pretty clear that just because the division asks for the highest set of penalties possible, that does not preclude the ALJ from imposing a lower penalty. The Commission made that clear in Montford. It's clear in the procedural rules which govern APs, and it's also clear because ALJ Elliott, in fact, did that himself in another case. And we respectfully submit that if the ALJ found that first-tier penalties were appropriate here, while we would suggest that second or third-tier penalties are, we would also argue quite strongly that there's nothing in the fact that the division asked for a higher penalty that precludes the ALJ from imposing a lower penalty. Thank you.
Thank you very much. Mr. Lippman?
With your indulgence, I will take this out of order. Let's
Surely.
start with the question about industry standard of care. Their testimony, their witness, as the ALJ found, could not identify one. Couldn't. He couldn't articulate one. Let's go to the second point. Harding did not review the assets, the triple Bs, before it bought the assets. How do we know that? We know that there's an analysis, and we know that on the front end, when the deal became announced, they kept asking for the information that they would need in order to do the analysis. And they placed the single A order only after they received that analysis and after they had enough time to go through it. I don't know when they did the analysis, but I know that the person who, the analysis that they claimed to be defective, that person didn't testify, so we do not actually know whether he was documenting an analysis that was done earlier when he wrote his memo, or whether that was an analysis that was done later. We don't know that. But more to the point. So the question about essentially, did you need to disclose Magnetar's participation? I submit to you that if the Commission knew the facts that came out in this hearing, this case would not have been charged. And here's why. My favorite line in the initial decision: in order to find scienter in this case, I would have to disbelieve every single witness, lay witness who testified at the hearing. What did the ALJ found? He found that the assets selected for Octans were no worse than any others selected by Harding for any of its deals. He found that those assets were no worse than any assets selected by, that were available in the market. Let's think about that for a second. Let's think about that. If Magnetar wants to short the assets and is putting bad assets into the deal, these assets, they're no worse than what's available in the market. But there's more. Magnetar, it came out during the hearing that Magnetar could not even analyze assets. They didn't have the technology. They couldn't have done it. They didn't know a good asset for a bad one. But maybe the most key point, we say this, and this is crucial. The proposed Rule 127B, right? That is a considered Commission analysis of what happens if a third-party participant plays a role in the creation of an asset-backed security, such as a CDL, and then shorts some of the collateral structure. What's the answer? The answer that the Commission gave was, under the circumstances in which they stand to make more money on their long position than their short position, there's no conflict of interest. Yes, conflicts must be disclosed. The Commission doesn't think it's a conflict of interest in a case such as this, where they're $200 million long and they're no more than $48 million short. $200 million long. They had an equity, they paid 94, I want to say, $1 million for their equity, or 96, and he says, the division says, I apologize, the division says they didn't care because they had this strategy. Here's what they should have disclosed to us as Brady that they didn't disclose. Internal Magnetar emails in which they're internal, where they're saying, we are going to be clipping a 17% coupon for the next 6 to 8 years, net of our short positions. That's an internal Magnetar email during the time that this deal was being put together. Another email that should have been disclosed to us as Brady. An email in which somebody challenges the Magnetar person who was in the deal and says, what's your angle with these ABX trades? And he comes back and says, the benefit of the ARB goes to the deal. And what other internal Magnetar email exists that they didn't disclose to us as Brady? A Magnetar email that says, where the person who is in charge of doing this deal is boasting to his boss and says, I cannot believe how well this trade went for creating extra cash for the deal. But there's more. They hired an expert. They hired an expert to prove that trade was bad for the deal. And the ALJ agreed with us that actually, no, the ALJ has a background in mathematics.
Thank you, Mr. Lippman.
If I may, before
Yes, go
I
ahead.
sit
Go
down,
ahead, go ahead.
because there's a lot here, and at the end of the day, there is. I don't think that if the Commission knew that Merrill Lynch did not know that it was being accommodated, I don't think that the Commission would agree. I think the Commission would look much more carefully as to why they bought those bonds. And the answer to why they bought those bonds is that they did do the work. There's no such thing as a bad bond. There's a bad price. They negotiated a discount. He's going to stand up and say, they did not negotiate a discount, somebody else did. Look at the OIP. The OIP acknowledges in the relevant provision that they got it at a discount. There are two discounts that went in. It was originally offered at LIBOR plus 385. They first offered to buy it at LIBOR plus 440. They eventually bought it at LIBOR at a 97, at a discount margin of 505. And if I may just, please indulge me, because I have to say, this entire time, we've been dealing with, this case has been a whack-a-mole for us. Things come up, and we have to track them down. We do not, our client does not have unlimited resources. We had 4 months to prepare. And what keeps coming up, and the reason I'm a little I don't even know what to say, is that I'm now out of time, and you need to hear this. I mean, you need to hear in their appeal to you, in one brief in which we say that their witness, actually, that the LJ found that their expert was wrong and that the ABX trade was beneficial to the deal, they put down a footnote and they say, no, they're wrong. Look at the initial decision, page whatever it is. Then we say, in our due process brief, we say whatever we say, and they come back and they say, oh, do you know how they got due process? Because in our argument on the same expert, the LJ agreed with us, and they cite to a different place in the brief. How about this? They have an email that they make a big deal of that says we had to pick best of the worst, right, or words to that effect. If you look at the brief that they submitted to you, that email is attached to a sentence. It's in a footnote. It's attached to a sentence talking about Octans 1. If you look at the OIP, it has nothing to do with Octans 1. But there's more. The OIP does not point out that it has nothing to do with that index. It has something to do with a different index. And you know what else? What else is that when you trace it down, when you find out what actually happened and you spend the time and effort and energy and resources, what you find out is in response to that email, one of the analysts that they're referring to, that analyst actually consulted with the other one. They changed their mind as to one of the assets that were relevant. I know I'm out of time. I'll be done in a second, I promise. They changed their mind. They changed collectively their mind as to one, and then decided, and so they switched it from a no to a yes. They decided that the other one should stay a no, and that was taken out of the relevant deal, which was not Octane Swan. This case never made any sense to us. It still doesn't make any sense. And the idea that Mr. Chow, this is, and I will sit down, I apologize. The idea that Mr. Chow could not care, Mr. Chow was more aligned with the investors in the deal than the investors themselves, because the investors bought bonds. If those bonds became discounted, they could sell them. He couldn't. He depended, and the ALJ found that.
Thank you, Mr. Lipton.
Thank you
very much. Mr. Fisher?
Thank you, Commissioner. Since I only have 3 minutes, I'm going to try to make 3 points and try my best to make them. First, I want to respond to a couple of points that were made by Respondents' Counsel. First, the division forcefully rejects any implication that they violated their Brady obligation. Every single document about which Mr. Lippman complains was handed to him at the commencement of this litigation. Second, I want to respond to Mr. Lippman's point about a proposed rule which was never enacted, which supposedly would have blessed this transaction. 2 responses to that. First of all, there's this thing about proposed rules that never get proposed. They don't mean anything. And the law is pretty clear that a proposed rule doesn't have any argumentative or persuasive force, especially whereas here it was never actually put into law. Secondly, if a rule is proposed which would have excused this behavior, the implication from that is that prior to the rule being enacted, that behavior was inappropriate. And if there had to be a rule put in to modify the standard, then that indicates pretty strongly that the prior behavior would have violated that standard. You don't, after all, put in a new rule to keep the same standards in place. Finally, I want to comment on some of the statements made by counsel with respect to the ALJ's finding on Norma. And I think maybe perhaps in responding to that, it would be helpful to put in a little context here. That context is that Merrill and Magnetar had trouble placing Norma. So Magnetar contacted Chow to tell him to, quote, please buy some Norma. Quote, remember who was there for you when you were a little guy. In response, Mr. Chow said he was a team player, and when Merrill pushed him to buy the BBB bonds, he said, quote, I never forget my true friends. The ALJ's credibility findings in this case were extensive and, I would submit, pretty unusual. He found repeatedly, quote, he could not credit Chow's testimony, that Chow's explanations were, quote, laughably implausible, and his testimony at the hearing was unbelievable, that Chow's statements plainly inculpate respondents, that his defenses were, quote, not convincing or not believable or unconvincing, and that his answers were puzzling and evasive. This is the context in which the hearing proceeded, and the material was not only the material and the evidence that the ALJ considered was not only Mr. Chow's incredibly evasive responses to testimony, it was also extensive documents, emails, Mr. Chow's testimony, as well as Harding's own business records. While hearsay is, of course, perfectly permissible in an administrative proceeding, we would submit that the evidence here rises far above the level of hearsay. And if anything convicted Mr. Chow, it was his own conduct, his own words and his company's own documents.
Thank you, Mr. Fisher. Thank you, Mr. Lippman, as well. The commission will take this matter under advisement. We are adjourned. Thank you.